Hi, my name is Ethan Buckhalter, and I'm a student at Osgoode Law School in Toronto, Ontario. In this episode of Case Law Minutes, we're going to be taking a look at the Supreme Court of Canada case Hryniak versus Mauldin. This is a case principally to do with the judicial regime surrounding summary judgment and is a landmark decision that has made significant changes to summary judgment motions and the interpretation of amended Rule 20 of the Rules of Civil Procedure. So first, a disclaimer. Um, this video is for informational purposes only. If you have a legal problem, it's always a good idea to talk to a lawyer who can give advice pertaining to your specific legal circumstances. Now for the facts of the case. The facts are as follows. In June 2001, Hryniak met with representatives of a group of American investors, in this case, Mauldin, where an agreement was reached for investment. The investors, being Mauldin's group, transferred 1.2 million to Hryniak's company, Tropus. In the aftermath, the investors' money was later transferred to an offshore bank account by Tropus and disappeared, which prompted an action for civil fraud brought by Hryniak because the return on investment was only just over $9,000 and the rest of the 1 million was lost. This also led to Mauldin and the investor group bringing a motion for summary judgment, which is really the focus of today's presentation on the analysis that the Supreme Court gives surrounding Rule 20 of the Rules of Civil Procedure. So ultimately, the two issues that the Supreme Court confronts in this case is the first, what is the proper interpretation of Rule 20 of the Rule of Civil Procedure? And relatedly, what is the standard of review on appeal for a motion of summary judgment? Now, before delving into the legal analysis, I thought it would be important to explain what Rule 20 of the Rules of Civil Procedure is in the first place to provide some much needed background. So first, Rule 20 sets out Ontario's summary judgment procedure, which is when a party can move for summary judgment to grant, dismiss all or part of a claim without going to trial. This rule was amended in 2010, and the goal of the amendment was on changing the perception and utility of Rule 20, whereby summary judgments should be seen as legitimate alternatives for adjudicating legal disputes. And ultimately, um, based on the amendments in 2010, Hryniak and Mauldin as a case is the first time that the rule has been interpreted by the court. And so there's a lot of precedential power that comes from this judgment. After getting some of the background information out of the way, like the facts and the issues, and also explaining Rule 20 and the procedure of summary judgments in Ontario, it's important to look at what the motion judge and the appeal judge ruled. So in this case, the motion court concluded that a trial was not required, but actually dismissed Mauldin Group's motion for summary judgment. It did use its powers under Rule 20 to weigh evidence, evaluate credibility, and draw inferences, but ultimately denied Mauldin's motion. Um, and this is, of course, was appealed. So the appeal court ruled that the case was not an appropriate candidate for summary judgment and dismissed the appeal because the court was satisfied that Hryniak had committed the tort of civil fraud. But what is really important is the Court of Appeal had decided that because of the factual complexity and large evidentiary record, the Mauldin Group's action was a type of action for which a trial was generally required. This was because there was numerous witnesses, various theories of liability against multiple defendants, serious credibility issues, and an absence of reliable documentary evidence. In this case, we get some really rich legal analysis from the Supreme Court, and this slide looks at specifically the court's analysis on issue number one, which is the proper interpretation of Rule 20 of the Rules of Civil Procedure and the amendments from 2010, making it more easily attainable for summary judgment motions. And so ultimately speaking for the court, Justice Caracas finds that summary judgment motions and the rules for the motion must be interpreted broadly. They must favor proportionality and be fair and have timely access for principles of access to justice. And in doing so, she really clarifies the regime and proper interpretation surrounding Rule 20. First, the principle that she starts with is there's going to be no genuine issue requiring a trial where a summary judgment motion can do the following. One, allow the judge to make the necessary findings of fact. Two, allow the judge to apply the laws to the fact. And three, it has to be proportionate, more expeditious and less expensive means to achieve a just result. Ultimately, this judgment is also very important because it grants additional fact-finding powers to the court. This is actually intended to illustrate that a trial should not be considered to be the default procedure, and instead the court further clarifies that evidence on a summary judgment motion doesn't need to be the same as at trial, but must be such that the judge is confident that she can fairly resolve the dispute. In deciding whether to use their fact-finding powers, the court further clarifies that it is in the interest of justice to do so. So in determining whether it is just to exercise their fact-finding powers under Rule 20 to arrive at a judgment at the motion stage instead of at trial, the court really needs to consider proportionality, but in other words, an assessment of the cost and speed of a motion against a trial, as well as the consequences that flow from litigation. The Supreme Court of Canada also seeks to address the proper standard of review for determining the appeals of summary judgment motions. And ultimately, the court finds that a motion judge's determination of whether a summary judgment should be granted is ultimately a question of mixed fact and law. Now, this is important because this goes against what the Court of Appeal found when they decided that determining the appropriate test for summary judgment and whether there's a genuine issue requiring a trial was actually a question of law. Ultimately, the Supreme Court decides that an appeal cannot be overturned absent a palpable and overriding error. And in this case, Justice Karakatsanis says, in my view, absent an error of law, the exercise of powers under the new summary judgment rule attracts deference. When the motion judge exercises her new fact-finding powers under Rule 20.04 and determines there is a genuine issue requiring a trial, this is a question of mixed fact and law. Now, finally, the decision in this case was the Supreme Court dismisses the appeal, which is important because there's a number of takeaways that come from this decision. Ultimately, this case sets out a roadmap for deciding summary judgment motions. So first, on a summary judgment motion under Rule 20, the judge must first determine if there is a genuine issue requiring trial based only on the evidence before her without using any new fact-finding powers. There will be no genuine issue requiring a trial if the summary judgment process provides her with evidence required to fairly and justly adjudicate the dispute in a timely and affordable and proportionate manner. If there appears to be a genuine issue requiring a trial, she should then determine if the need for a trial can be avoided by using the new powers under Rule 20.04 and their fact-finding mission. She may, at her discretion, use those powers, provided that their use is not against the interests of justice. Their use will not be against the interests of justice if they will lead to a fair and just result and will serve the goals of timeliness, affordability, and proportionality in light of the litigation as a whole. So ultimately, there's a few takeaways here. So first, the court's decision demonstrates that a trial should no longer be considered as a default procedure and ultimately has greatly increased the availability of summary judgments in Ontario. And obviously, Hryniak and Mauldin significantly has changed the landscape of civil litigation in Canada. It has broadened the circumstances in which summary judgments can be granted, making it a more accessible and efficient tool for resolving disputes. And the decision really emphasizes the importance of proportionality, efficiency, and affordability in the civil justice system. If you'd like to learn more about this case and read it for yourself, please find the link embedded on the slides in this video, as well as under Hryniak and Mauldin on Canley. Thank you for listening to this episode of Case Law Minutes. We'll see you next time.